All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Justin Bork, Kiera Moffitt, Trevor Rogers, CR 25-283 waiver of arraignment filed, and pretrial is set April 2nd. Kiana Walker, Jalen Fairley, Jalen Jamal Fairley, Chase Harrison, Bradley Bearden, Clinton Tinsley, thank you, Mr. McBride. Christopher Yates, thank you, Mr. Pointer. Ryan Norris, Christopher Blevins, that's your phone, you better turn it off. Wyatt Berkwin, Nathaniel Brooks. I see Mr. Brooks on the Zoom waiting room. We'll recall his case. Zachary Campbell, CR 25-32. Mr. Campbell is in the Texas Department of Criminal Justice on a 3-year sentence out of Kaufman County. I'll recall that case. Savannah Cooksey. Here. Deanna Dial. Susanna Frisbee. Joshua Gomillion. James Goodson. Ronnie Earl McGee, CR 25-135, is verified in custody in Smith County. Court will recall that case. Julian Romero. Joseph Tudor. Michael Weaver. Jalen Young. I have CR 25-224. I have him verified in custody in Caddo Parish, Louisiana. Court will recall that case. Cletus Pippin. Here. Stephen Richardson. Present. Councilman. Thank you, Mr. Wheeler. And we have a couple of 10 o'clock cases. Just for everyone's information, we'll have a 10 o'clock hearing on Zoom with Big Spring State Hospital. Mr. Gerards will need to be timely for that. And we also have a plea with Mr. Mansanis with an interpreter. Do y'all have the plea paperwork ready to go on that, Mr. Schmidt? Stay here.
It's just about ready. I noticed one error.
Okay. All right, just so we can get that, we'll take up Mr. Gerard right at 10. I'll bring in the interpreter, and we'll let Mr. Schmidt do his thing. Then we'll, after the conclusion of Mr. Gerard's case, then we'll do the plea for Mr. Mansanis. All right, we have anyone in the courtroom, your name's not been called, and you expect to be on the docket? All right, we have any counsel that's ready? Mr. Wells?
Mr. Pippin, Judge.
Mr. Pippin, if you'll come forward. This is cause number CR 25-11, State versus Cletus Pippin. Mr. Pippin set for pre-trial today. Any announcements, Mr. Wells?
Judge, we just need to get this on the docket call. We've got a letter from the insurance carrier that they've settled both claims, but we don't have the releases yet. The state wants the releases. So if we could get it on a docket call.
All right, court will set Mr. Pippin then for docket call. How much time do you need, Mr. Wells, do you think?
30 days, I guess. The insurance companies move a little slow.
All right, what about Tuesday, March 31st?
March 31st would be just fine.
All right, court sets Mr. Pippin then for docket call March 31st at 9 a.m. Once he signs his notice, he's free to go.
Thank you, Judge.
Go ahead, you ready?
Yes, sir, Your Honor. Bradley Bearden.
Mr. Bearden, this is cause number CR 25-195, State versus Bradley J. Bearden. And Mr. Bearden is set for docket call. Go ahead, Mr.
Your Honor, we have received an offer. We've received all the discovery. We're negotiating. I spoke with the state. I think if we could get one more setting. Hopefully we'll be able to come up with an agreed resolution if we could potentially get that March 31st setting.
No objection.
All right, there'll be no objection. Court sets Mr. Bearden then for docket call March 31st. I'm gonna make that a final docket call, Mr. Head, so that, Mr. Bearden can make a decision that day how he wants to resolve this case.
Yes, sir, Your Honor. And that would be 9 a.m., Your Honor?
9 a.m.
Yes, sir. Thank you, Your Honor. May we be?
Need a motion, Mr. Head? Yes. Before you go ahead and get your client, come on up.
Thank you.
All right, court call CR 25-222 and 223, State versus Christopher Matthew Yates. Mr. Pointer, I think we're set for docket call today.
That's correct, Your Honor. Defense is requesting another docket reset where the district attorney and I believe are making progress on trying to reach an amicable solution.
Yes, Your Honor. There's a couple of moving parts here. We are working on the case. There's also another county involved, so we're trying to get everything wrapped up globally. So we would join in a request for an additional docket call.
March 31st work for you, Mr. Pointer?
That's fine, Your Honor.
All right, court sets Mr. Yates then for docket call 9 a.m. March 31st, both cases. Once he signs his appearance, he's free to go.
Thank you, Your Honor.
You're welcome. Mr. Harrison?
Yes, good morning, Judge.
Case Alan Harrison, CR 25-131. Mr. Harrison, don't do that again. Don't do that again, because that's there for a reason, okay? So you walk around and come up here, okay? All right. All right, Ms. Harkins, I think Mr. Harrison's set for pretrial.
Yes, Your Honor, we're here. We're ready to set it on a docket call setting. We're just gathering some CPS and counseling records, which we'll submit to the court for review.
All right. March 31st.
That works, Your Honor.
All right, court sets Mr. Harrison for docket call March 31st at 9 a.m. Once he signs his appearance, he's free to go.
Thank you, Your Honor.
Christopher Tinsley, this is CR 25-238. I'm sorry, not Christopher, Clinton Ray Tinsley. And Mr. Tinsley is set for pretrial. Go ahead, Mr. McBride.
Morning, Judge. I just substituted into this case. The court may be aware at the last setting, the defendant wanted to switch lawyers, so we have hopped into it. It sounds like there was some negotiations, but before the client makes the ultimate decision, trial versus, I want to make sure I understand the offer that's on the table, see if we can do any better, just typical deal. There's also some CPS stuff that I'm not sure, I don't think anything came of it, but I want confirmation of that as well. So if we could get a push, I want to mention also, I filed some motions, or they should be filed today, pretrial motions. If I could ask the court not to look at those until we make that ultimate decision. I know sometimes courts start ruling on, don't bother until we know which way we're going to jump, but they're there. I'd also reserve the right to add new things, maybe another motion in limine if there's something else I forgot or didn't know about the case as of yesterday, because I'm just digging into it. So expect some motions. If I could ask the court to ignore those for a period of time till we know we're going to trial, then maybe have a pretrial just for that before the picking of a jury or something like that. And then let's see what we're doing here, if that's acceptable. So yes, another pretrial. Long way of saying another pretrial, please, sir.
State.
No objection, Your Honor.
All right, court will set Mr. Tinsley for pretrial March 31st at 9 a.m. And once he signs his appearance, he's free to go.
Thank you, Judge.
Well, Mr. Hood. Mr. Wheeler, you ready?
We're ready, Your Honor. For entry of plea on Stephen Richardson.
Mr. Richardson? It's cause number CR 25-12, 2024-219. Give me just a moment. I'm going to pull up the plea agreement. All right, Mr. Richardson, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Stephen Ray Richardson, is that correct?
Yes, sir.
And Mr. Richardson, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me what condition that is?
Bipolar, depression, severe depression, PTSD, and anxiety.
Are you currently on medication or treatment for those?
I had to quit about 2 months ago, but they just turned my check back on, so I should be starting them back up.
Okay, so you're not on medication or under treatment right now? Do you feel like in any way, Mr. Richardson, that your mental health disorder is in any way affecting your ability to rationally understand what's going on in this case and affect your ability to communicate with your attorney, Mr. Wheeler?
No, sir, not.
Are you pleased with Mr. Wheeler as your attorney? You and I had a hearing not long ago in which I discharged Mr. Schmidt as your attorney, and you asked for another court-appointed attorney, and I believe the next day I appointed Mr. Wheeler. Are you pleased with Mr. Wheeler as your attorney and the work that he's done for you?
Yes, sir.
Do you have any questions about your plea agreement or anything else that you've signed today and reviewed?
No, sir.
Mr. Wheeler, do you believe Mr. Richardson to be competent to enter into this plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
He is competent, Your Honor.
All right, and you believe he's entering into the plea intentionally, knowingly, voluntarily?
His act is freely, intelligently, knowingly, and voluntarily taken today. He understands the nature of the plea agreement, and he is entering a plea of guilty, waiving his reading of the indictment, and he understands now that he is legally guilty.
All right, thank you, Mr. Wheeler. All right, Mr. Richardson, in your cause number CR 25-12, you were originally indicted with a state jail felony offense of a burglary of a building. I see today that the plea agreement would be for you to plead no contest to the lesser included offense of burglary of a building. Was the original charge burglary of a habitation?
Yes, Your Honor.
This is burglary. Are we sure about that, Mr. Hartwell?
Yes, sir.
It was burglary of a habitation?
Yes, sir.
So the docket's wrong?
Yes, Your Honor, it was originally indicted as burglary of a habitation. The house was not actively occupied, which is where we arrived to this plea agreement,
Okay.
but it was originally indicted.
Okay. All right. And so, Mr. Richardson, the agreement today would be for you to plead no contest to a lesser included offense of a burglary of a building, which is a state jail felony, and does carry a range of punishment if you were to be convicted and sentenced to not less than 6 months or more than 2 years confinement in a state jail prison, and a possible fine of not more than $10,000. I see the plea agreement is upon your plea of no contest, the state's asking the court to review the evidence, to find that there is sufficient evidence to convict you of the offense, to assess your punishment at the maximum 2 years confinement in the state jail prison. But they're also recommending that the court suspend that sentence today and place you on 3 years of community supervision. They're asking the court to assess a $1,000 fine plus court costs and reimbursement fees. In addition, the state would be dismissing under section 1245 a charge of harassment with a previous conviction, which is a class A misdemeanor. Mr. Richardson, you've reviewed all of this plea agreement with your attorney, Mr. Wheeler, and you understand what you're entering into today. Is that correct?
Yes, sir.
All right. Understanding the plea agreement, understanding the range of punishment, Mr. Richardson, how do you plead to burglary of a building, a state jail felony?
No contest.
All right. And Mr. Richardson, has anybody threatened, forced, or pressured you to plead no contest to this charge?
No, sir.
All right. The court will accept the defendant's plea of no contest. And you understand, Mr. Richardson, that a plea of no contest is the equivocal of the court accepting a plea of guilty to the offense if there's enough evidence to support the case. You understand that?
Yes, sir.
All right, Mr. Wheeler, any objection to the evidence being admitted?
No objection.
Evidence is admitted, and the court does take judicial notice of the defendant's no contest plea. Anything further from state?
Your Honor, only that we did reach out to the alleged victims in the case. They were supportive of the plea. When we sent out restitution documentation, they did not return it.
Thank you, Mr. Will. Anything further from defense?
My client does have a question about how many hours community service is going to have to serve, but that's the only other issue.
Let's see, I believe that was probably in the conditions of probation.
It was, I just don't recall.
Sure, let me look, I'll tell you. $210.
And over 3 years, that is 70 hours, so roughly 5 hours a month. Okay.
It'll be, well, in the conditions, it says at a minimum 10 hours a month.
10 hours a month.
Discharge.
Well, good, because that's what I told him.
Yeah. All right. All right, anything further from Mr. Richardson?
Nothing from the defense. Your Honor.
All right, then the court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court hereby follows the plea agreement. The court hereby convicts Stephen Ray Richardson of burglary of a building, a state jail felony. The court assesses punishment at 2 years confinement in the state jail prison. The court suspends that sentence today, places the defendant on 3 years community supervision, orders him to pay a $1,000 fine, court costs of $290, and reimbursement fees of $1,360. Further, the court places the defendant on a mental health caseload, and the court dismisses under section 1245, cause number 2024-219. Mr. Richardson, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the judgment. I'm gonna have you come forward to be fingerprinted with Sergeant Martinez. After that, you'll meet with the probation officers.
Thank you, Your Honor. May I be excused?
Mr. Wheeler, I appreciate your service to the court.
God bless you. Thank you.
Morning, Mr. Sanders.
Morning, Judge.
I thought that was you. I looked over there. I'm like, I haven't seen Mr. Sanders in long. Is that him? You know, I talked to Patty. I was like, Patty, is that Joe Sanders?
That's all right. Am I looking better than you remembered? Is that?
Looking young. I mean, you don't come over here enough. You
I
look
know.
A lot younger. And so Patty and I were talking about it. We thought you were mad at us or something. We haven't seen
That's
you
right.
in
That's
forever.
right.
So I'm glad. Hope you're not mad at us. You're back. So
Well, I've forgiven everything.
You've gotten over it?
Yes, that's right. I've moved on, so.
good for you. Good and good for us. Good for us. All right, court calls, cause number CR 25-270 and 271. State of Texas versus Ryan Dwayne Norris. Mr. Sanders, I believe that we're set for pretrial.
Yes, Judge, and Judge, I was gonna ask if we could set for a passage to another pretrial. We've been in discussion with the state. We don't have an offer yet. There's still some discovery matters, and also I think the state's reaching out to the alleged victim in the case, and so we don't have an offer just yet anyway. If that March 31st date, if that would work.
State.
Yes, Your Honor, we're working on making sure that everything is with Mr. Sanders. If we could get another pretrial, that would be beneficial.
All right, court sets Mr. Norris then for pretrial March 31st at 9 a.m. And once Mr. Norris signs his notice of appearance, he is free to go.
Thank you, Judge.
Thank you, Mr. Sanders. Good to see you.
Good to see you too.
Justin Bork. This is cause number CR 25-244, State versus Justin Ryan Bork. Mr. Bork, I believe that I had reset you from arraignment probably about a month ago so that you could hire an attorney at your request. Have you hired an attorney?
I'm in the process. I've been talking with Greg Waldron. I'm just trying to come up with all the money for the down payment. If I can just get a little bit more time,
How much more time?
3 weeks, 4 weeks.
And you're guaranteeing that you'll have Mr. Waldron or someone else retained by then?
Yes, sir.
I'm gonna reset you to March 31st. That'll be your final hearing on status of attorney. Okay, so I expect you to show up that day with an attorney.
Yes, sir.
March, I'm sorry, did I say May? Say May. It's March 31st. Okay. I'll also be arraignment. Here you go.
Thank
you. Kiara Moffett, CR 20-298. All right, Ms. Moffett, I believe that I also reset you and gave you time to hire an attorney. Did you hire an attorney
I will be hiring mine on the 25th, Wednesday, next week on Wednesday.
next week?
Yes,
And
sir.
who are you hiring?
Jim Hugler.
Jim
Jim
Hugler?
Hugler. Jim Hugler. He's
Hugler,
out of
okay.
Yeah.
Mr.
Sorry.
Hugler, okay, yeah, sorry. You were saying it right, I was hearing it wrong, so
It's
that's,
okay.
that's my fault, that's my fault, Mr. Hugler. You said that'd be next week, okay. I'm gonna reset you then, Ms. Moffett, then for March 31st at 9 a.m. Once you sign your notice, you're free to go.
Okay. Thank you.
Kiana Walker. All right, Walker, this is a sanctions court hearing, the cause number CR 21-312. I've got some notes that says that you're not paying probation fees, you're not paying your fines, you're not working community service. Is all that true or not true?
That's true.
That's true. And why are we not doing those things?
Well, I was doing it, but for the last 2 years, a lot of things have transpired as far as I've taken a lot of losses. So I lost my job and my grandmother and my dog. And so I've just been trying to rebuild. And right now I'm in the process of, I was 5,800 behind with my rent. So my landlord worked out a thing with me and I have to pay 1,800 to live there. So right now, I don't have any money. Like I work a job, but now I only make $17 an hour. So I'm really just trying to stay afloat. So I've went from 5,800 to now I'm 1,700. So my plan is, which I know I have 15 months left on probation and I do everything that I supposed to. I was doing the community service as well. But the job that I have, they did start giving us overtime for like 3 months. So that allowed me to get up on my rent. So with the plan that I have now paying the 1,800 for my rent, in 3 months, I'll be up on that. So the money that I'm used to already paying, the extra 400, I was gonna pay that toward my probation and get everything back in line because I do plan to finish this probation in my 15 months. It's just everything is just haywire and I'm really trying to just get everything together. So I'm working on it. I have a plan on it. And the community service, I will be able to start back at least in the beginning of March because I'm not doing overtime at the job anymore. And Saturday was the day that we were working overtime. So I am working on everything and I just ask that you give me a little more time. Because like I said, in these 15 months, I plan to finish with my fees paid and everything done, but it's just really hard right now. And it's not that I'm deliberately not paying my probation or doing, it's just everything is really hard. I've lost jobs because of economy. Like they let all the temps go because the economy was bad. So then I have to, try to stay afloat and it's really, really hard right now, but I'm doing everything I can to stay afloat.
All right, and I understand, life comes with hardships and there's rough patches here and there. I understand that. But I'm glad to hear that you have a plan. A lot of people walk up here and they don't have a plan. So I'm glad to hear you have a plan to get caught up. So, obviously my job is to make sure that you are staying compliant since I put you on community supervision, that you're staying compliant and doing the things that you're supposed to do. So what I'm going to do in sanctions court is I'm going to give you some benchmarks and goals that you have to meet every month so that we can try to get you course corrected and get you caught up so that you can complete within the 15, 17 months, whatever it is, so that you can complete your probation. Okay. So this is what I want to do. Can you pay $100 towards your probation fees, by March 31st?
By March 31st, I can't commit to that.
And then, so what I would do is I would order you, it's basically $200. It's $100 towards probation fees and $100 towards your clerk fees or your judgment fees at the clerk's office. And then 20 hours of community service before March 31st, so that you got the rest of this month and you got all of March to get that done.
Okay, so 20 hours
Yeah,
and
we're gonna write it down for you. Yeah. So $100 to probation, $100 to your collection fees at the court, and then 20 hours community service. What we're trying to do is get you caught back up so you can complete your probation on time.
Okay, and can I ask you a question? Can I pull up my phone? Because I have a list of the amount, and I just want to make sure that the amount that I have is the.
I'll tell you what, so I got other cases, but when you get done, if you come over here and meet with the probation officers, they can tell you exactly what you owe. And then you go to the clerk and they'll tell you exactly what you owe.
Okay,
'Cause I don't know, because I don't have access to them.
okay,
Okay, and then I'm gonna UA you today, okay?
okay.
All right, so sign that notice and then you'll come over here and meet with Ms. Burns. She'll be able to answer your questions, okay? Is Jalen Fairley here? Jalen Fairley? You're here? Okay. I called you earlier. You weren't here when I called your name, right? Were you late? Okay, all right. Is your attorney here, Mr. Carpenter? All right, why don't you step out in the hallway and give him a call, find out where he's at, okay? All right, court's gonna stand in recess for 20 minutes and give Mr. Schmidt opportunity to speak with his clients. So you're free to come and go throughout the courtroom. Court's in recess until 10 a.m.
Morning.
Good morning, Ms. Fajardo. Can you see and hear me okay?
Yes, sir.
We're not quite ready on Mr. Mansanis's case. His attorney is speaking with him across the hall to do the plea agreement. So what I'm going to do is just ask you to turn off your video and mute, but to stay in the session. I'm actually going to take up another hearing in the meantime. Once we complete that, I believe that Mr. Schmidt and Mr. Mansanis will be ready for their plea.
Yes, Your Honor. No problem.
I'll tell you what, I'm going to go ahead and swear you in at this time. Okay, if you'll raise your right hand, state your name and your license number.
My name's Cecile Fajardo, certified Tagalog interpreter in California and Florida. My California certification is 597225.
All right. Ms. Fajardo, do you swear that you will make a true translation of the statements of the court, questions of the attorney, and the testimony to be given by the defendant in the matter now on trial to the best of your skill and judgment, so help you God?
I do.
Thank you. Okay, and if you want to, you can just, like I said, you can mute and turn off your video. We'll be with you shortly.
Yes, Your Honor. No
Thank you,
problem.
ma'am. Appreciate you being here.
You're welcome.
Morning, Mr. Lowe.
Morning, Judge.
How are you doing today?
I'm fine, sir. Thank you.
All right, I do have Big Spring Hospital in the waiting room and Dr. Alpac, I believe is maybe how you say that. Also have him. So I'm gonna go ahead and bring them in at this time and then I'll announce the case. We'll get going.
Thank you.
Is there a place where I can see?
Your Honor, may I bring that back up over here so we can see the folks on the screen?
Yeah, absolutely. Yeah, and you'll have to turn the video on because I just turned it off. And the battery should be good, so you should. So what I'll do is I'll turn off this camera here if you are going to be on, just so it's not so busy. Hey, Mr. Gerard, there we go. All right. Good morning, Mr. Gerard. Can you see and hear me okay?
Yes, sir.
Hey, give us just a moment. We're still getting set up and then we'll get going on your hearing, okay?
Okay.
Your Honor, our video says disabled by host.
Try now. Try now.
Still.
Let's try now. Here we go. All right, good morning, everyone. We're going to go on record now. This is cause number CR 22-67, State of Texas versus Robert Gerard. And appearing today via Zoom for Mr. Gerard is his attorney, Mr. Doug Lowe. Also appearing is Mr. Robert Gerard, defendant in this case. and he is appearing from the Big Spring State Hospital. Also appearing for the state of Texas is the Criminal District Attorney, Ms. Tonda Curry, and also appearing is Dr. Alpac. And so, Dr. Alpac, if you'll raise your right hand, I'm going to go ahead and place you under oath. Do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do, Your Honor.
All right, thank you. And during your testimony, doctor, if you'll just speak up loudly and clearly, I do have a court reporter here and she's going to be taking down what's discussed. In addition, if the attorneys have any questions, just make sure you allow them to finish their questions before you give any answers so that we're not talking at the same time. Okay.
I'll do your best.
Thank
I'll
you,
do my
sir.
best.
Appreciate it. All right. The purpose of today's hearing is for whether or not Mr. Gerard should be renewed on his inpatient extended mental health services under Chapter 46C of the Texas Code of Criminal Procedure. Mr. Lowe, would you like to ask any questions or make any statements at this time? Otherwise, I would turn it over to Ms. Curry.
No, we'll pass it over to Ms. Curry.
Ms. Curry,
Thank you, Judge.
you're welcome.
Judge, I don't appear on the screen. Can everyone hear me?
We see you on the screen. It may
Okay.
just be a self view, but everyone can see Ms. Curry. Is that correct? And let me change your name in there so it's clear. And you may have to just change your view up there to either gallery view. Can you see everyone else?
I see everyone else, Judge. It's fine. I just wanted to make sure they could see and hear
Yes,
me.
I can see it.
Okay. Good morning, Dr. Alpac. Would you begin by stating your name for us and giving us your education background?
I'm Goka Alpac. I'm a staff psychiatrist at Big Spring State Hospital. Currently employed by University of Texas as an assistant professor and contractor with Big Spring State Hospital.
And how long have you been in that position?
Almost 3 years right now.
As a part of your duties with the state hospital, do you routinely see people who are committed there after having been found not guilty by reason of insanity?
I do have quite a few patients acquitted for injury, yes.
And as a part of your treatment with those patients, is it incumbent upon you to determine whether the patient remains in need of further care or whether they are safe to be released?
Yeah, that's part of my job.
And are you familiar with the patient, Robert Gerard?
Yes, he's under my care since the December of last year.
And have you reviewed Mr. Gerard's case file, his medical, particularly his medical and mental health prior situations?
Yes, ma'am.
Does Mr. Gerard have a mental health diagnosis at this time?
Yes, ma'am. He is diagnosed with schizoaffective disorder, bipolar type.
Is he receiving treatment, medication, or some other type of treatment for that disorder?
Yes, he is receiving medication. Just to be clear, he's on quetiapine. This is an antipsychotic medication, 500 milligrams daily. And on top of that, actually, he's on psychotherapy since September of last year. I believe he is continuing with actual Dr. Torres to go over psychotherapy. And as well as actually he's on work therapy program. He's been attending horticultural. And this has been reported to me, and actually he's reliable, works very hard, and get along with other peers as well. And we do have an NGRI program in here. This is kind of an actual classes. They are going over to actually the therapy department. What we have is, so they've been actually educated about what the NGRI commitment is, what are the requirements, and what are the expectations when they get out, or what would be the requirements to get out. And so we do have some other classes as well, and he's been attending almost each one of them.
Have you made a determination whether at this time Mr. Gerard meets the criteria for release or whether you are requesting further treatment for him?
As you may see actually from my CME as well, he is psychiatrically stable, but at the same time, for the public safety, there are still several risk factors we need to address, and those are not addressed yet. And we already in the process of him being referred into risk assessment. We already referred him, and our psychology department already started the process for the preliminary testing on him. And then we're going to be referring official risk assessment. And in the lights of official risk assessment, we're going to be come up with an outpatient management plan. We do have some kind of actual ideas, and I believe actually we already discussed with Mr. Gerard as well. There are a lot of step-down facilities, in Texas. I believe he is eligible for those services in Texas. And I believe he's willing to do that as well. So we're in the process of doing the application for that matter. But at this time, so since we don't have a safe and secure placement ready, and we don't have the outpatient management plan or risk assessment ready, we're requesting him being staying at the hospital with us until we can get this process done.
So at this time, you're asking the court, or you're recommending to the court, that he continue to receive the inpatient psychiatric services at your hospital?
Yes, ma'am.
I'll pass the witness, Judge.
Mr. Lowe, your witness.
Thank you, Your Honor. So, Doctor, I'm looking at your certificate you have filed with the court. And so I'm going to go as quick as I can. First of all, let me tell you, I appreciate the work that you do there at the hospital. And I talked to Robert last week, and he's doing so much better. And in fact, he's lost like 40 pounds on his more healthy diet, right? And so his diabetes is better under control. He's just living a better, healthy lifestyle. And on Robert's behalf, I want to tell you, I appreciate that. So we'll appreciate it once again. So as far as the reason for his commitment, you did not check that he was likely to cause serious harm to himself or to others. And
no, I don't think so. I don't think so. He's imminently danger to himself and others.
And so we did talk about that. He does have symptoms which lead you to believe that even with medication and psychotherapy, that he needs to continue his hospitalization. Is that true?
Yes, it is. This is a chronic condition, and he's in remission right now. Actually, I believe he's psychiatrically stable, but along the way, he might be having actually up and downs. Everybody has, by the way, and
True.
but I believe he doesn't have any refractory psychos, anything going on. It might be some kind of negative symptoms. He's kind of actually more isolated to himself, but at the same time, it's kind of actually might be a normal attitude or behavior because he's been actually living with other patients suffering from mental illnesses, and I believe he has really good relation with other peers, and he's get along with staff members. I'm not hearing or anything reported back to me, any problems or anything going on. There's only one incident. He became an actual aggressive, but it was a year ago, and it was just with another patient. He just got an actually physical fight with him, and but since then, it was actually I didn't really hear or reported back to me anything about it. There's some kind of changes at the hospital. We are going on unit assignments just because of that. It's actually his care is transferred to me, and there's nothing wrong about it. It's actually him being his treatment is sexually changed or anything. It is just because of the hospital unit assignment plan at this point. And I've been actually his psychiatrist since December, and I saw him actually more than a couple times, and all of them is actually he's very respectful, polite, and kind, and I don't see any actually active hallucinations, any psychos, anything going on. There might be some negative symptoms time to time. He has kind of an actually isolating to himself, but other than that, it's like I don't see any problems.
One of the things that we saw early on was hallucinations. Even with me, he was having hallucinations. Has that resolved to do you think?
I believe
With the
so. I believe so. I didn't see him actually respond to the internal stimuli. I never been getting actually reported back from the staff members because we do have staff members actually monitoring him. And here, I have morning reports every day in the morning. So my nurses and actually my staff members actually reporting back to me and actually anything going on about the patient, if they're refusing their medications or, observed as responding to internal stimuli or any psychotic behaviors or any behavioral events actually. So, and I believe he's stable in terms of that. And that's why actually we think his treatment team, we think that is actually he's ready for risk assessment. After we got his actual care, about a month later, we just referred him actual risk assessment, and the process already been started.
Okay, and so I think what Robert really wants to know is a timetable. What we're looking at is for, and I know that you're smiling, but and I think that's real important to Robert because he's made a great improvement. I know, of course, we know it was a very serious offense, and that he's in a place where he needs to be. But can you kind of rough sketch out as a timeline so Robert can know what he's looking at? And I know the risk assessment has to be completed. We're looking at halfway houses or something like that. But just tell us where we think we are.
I believe halfway house is not a really good option for him. I believe actually there should be in a semi-structured
Okay.
kind of an actual environment would be a better option for him. And step down is actually, I believe it's, he's eligible for that, the services in Texas. And they have in-house psychiatrists or mental health providers, as well as actually some kind of like supervision, but there are a lot of actual freedom than compared to actual hospital. And I believe he's already been aware of actual step-down facilities as well. And for the timeline, I just have an actual meeting this morning with with our actual hospital social worker department. They're the one actually, responsible parties for reaching out to other facilities and everything. And to be honest, actually, those are the third-party agencies. So, their process, we cannot actually really control over. We don't have anything to say about it. And it takes months, it's definitely actually more than 90 days. We are just requesting actually up to 1 year commitment. But whenever we have everything ready, risk assessment and actually, outpatient management plan and everything ready, we're going to go and actually, get back to you guys, actually let you know about it when we have the drafted, outpatient management plan. At the same time, taking into consideration of the seriousness of, as you said, actually, index offense. But at the same time, we do have a process in our hospital. Those outpatient management plan needs to be approved by our forensic committee at the hospital, and then it's actually going over to central office in Austin. HHS needs to actually approve that as well. So, given all these circumstances, it's going to take some time, but I don't have the time frame for you, unfortunately.
Oh, so the commitment is for as long as a year. So, are we talking about within a year or more than a year?
I hope within a year. Yeah, I definitely hope that is actually within a year. And, unless there is something really, another, we cannot say for sure is actually so for about the future. If he's going to be actually, deteriorate or having some sort of actual symptoms or signs, I'm not expecting anything, by the way. I'm just putting out there. And, but yes, within a year, I believe we have a really quite a big chance actually him being discharged and back to community.
Excellent. So that's all I have, Your Honor. I'll pass the witness.
Thank you, Judge. Doctor, you did not find in your report to the court that Mr. Gerard was likely to cause serious harm to himself or likely to cause serious harm to others. But you did find that he is suffering severe and abnormal mental, emotional, and physical distress, experienced substantial mental or physical deterioration of his ability to function independently. Correct?
Yes, ma'am.
And is that still your opinion today?
Yes, and if I may actually clarify on that, just because we don't have an actual safe and secure placement ready, And this condition he's been suffering is a chronic condition. If you don't have actually, all the risks and everything is addressed in his outpatient management plan, if we're going to be discharging him back to community today, that's my concern. Is actually he may deteriorate quickly. He will not going to be actually having the services and everything ready. And we need to be careful about the public safety in terms of not only him, but public safety as well.
Thank you, sir. That's witness church.
Mr. Lowe.
No more questions of witness, Your Honor.
Dr. Epic, I do have a quick question, just kind of a follow-up on what Ms. Curry was asking you about. So if your opinion is that you believe that he is suffering from severe abnormal mental, emotional, and physical distress, and that's coupled with experiencing substantial mental and physical deterioration of his ability to function independently, then you said also in your opinion that he's not able to make a rational and informed decision as to whether to submit to treatment. All that's true, is that correct?
I believe he's able to make a rationally informed decision at this point, but he's suffering from severe abnormal mental, emotional, and physical distress. That's the chronic condition. Is actually, the name of the condition is schizoaffective disorder bipolar type, and this is an ongoing illness and chronic illness. That's why it's actually, the second part is actually yes, and so this means to us actually he's at risk for acute deterioration if he gets to be discharged today. That's what I mean actually with that.
Thank you. All right, any further questions, Doctor?
No, Your Honor.
All
Oh,
right.
Your Honor.
Thank you, sir. I know you're a very busy man and you're excused from this hearing whenever you wish, or you're welcome to stay.
Yeah, I can actually turn off my camera and mute myself, but I would like to be actually here
Yes.
until the court,
Yes, sir.
if I may. Thank you.
Yes, sir. Thank you. Ms. Curry, anything further?
No, Your Honor.
Mr. Lowe, anything further? Would you like to call Robert? Yeah.
Well, I don't think, is Robert been sworn?
No, not yet.
Why don't we just, he's there, and may he want to say something, he may not want to say anything, but if I would like to ask him if he wants to say something.
Yeah, we're gonna get him. All right, good morning, Robert. Can you see and hear me okay? All right, let's see, we don't hear you. Do you have a microphone? Is there a microphone connected to this PC or laptop that you're using?
We were having malfunctions today too.
Okay, well, it's working now.
Here, I can move it closer to him.
Oh, that's fine.
How are you, Judge Martin?
I'm doing fine. It's so good to see you.
Thank you. Good seeing y'all as well.
All right, Robert, I'm gonna have you raise your right hand. I'm gonna place you under oath, sir. You swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth. So help you God.
Yes, sir.
Thank you, sir. All right, put your hand down. Mr. Lowe is gonna have some questions for you, and Ms. Curry, you may also as well. Mr. Lowe.
So Robert, let me ask you, did you understand what the doctor says as far as what he recommends as far as a step down at some point in time?
Yeah, and he had already, yes, sir. He had already told me he was referring me to a risk assessment. He told me about my attendances, and then he told me about the step down opposed to the group home setting, and the importance of continuing treatment afterwards. And yeah, I understood everything. Yes, sir.
So you understand why there's a reason why you need to stay there for a while longer until there's a plan in place. You
Yes, sir.
understand that? All right. And do you have any complaints with that today,
No, sir.
Robert? Do you have any complaints about anything that's been going on as far as the last year?
No, sir.
You're happy there, I guess.
Yes, sir.
As you can be.
Yes, yes, sir. There's a lot of liberties here, so I'm not. When they say I'm ready, I feel like I'm ready. So I'm not in any rush to do anything. I just want everything I do to be fruitful and be something very good for me, fruitful for me.
And I think you said you told me last week your diabetes is in a lot better shape than it was when you got there.
You're right. Yes, sir. A whole lot better.
You're
Yeah, they
eating
took me
better.
off the shots, and now I'm just taking metformin now.
All
And
right,
then
well, that's
like
great.
my shots are PRN, and also my finger sticks are PRN because my blood sugar's been so well.
All right. I don't have any more questions unless you want to say something else, Robert. You
No,
good?
I'm good.
All right, pass the witness, Your Honor.
Ms. Curry, you have any questions?
No, Your Honor, thank you.
All right, Mr. Clark, do you want to say anything else? I think Mr. Lowe gave you the opportunity, but is there anything that you want to tell the board about your stay?
No, you were talking to me?
Yes, sir. Yes, sir.
Oh, no, sir.
Anything at all? Doesn't have to be about this hearing or anything else.
Oh, no, sir. I've just been finishing these classes. They transitioned me from an NGR 101 to 201. So I'm learning a lot about my diagnosis. I got my COPS-D certificate, which is for the drug rehab. And I got the anger awareness and anger management certificate. So I'm getting a lot of help here. So it's wonderful.
All right, good. Well, I'm glad to hear that. Glad to hear that.
Thank you. I thank you for the opportunity. That means a lot. It really meant a lot, Judge Martin, for you to give me a second chance at life.
Well, absolutely. I'm glad to hear that. And it's not just me. It's Ms. Curry, Mr. Lowe.
Thank you, Ms. Curry.
This really was a team approach because everyone having to balance making sure that justice is done, the community is protected, but also that you receive what you're entitled to receive because you're suffering.
Yes, sir.
So it's a team approach, and you're part of that team now. So
thank you, sir.
So I'm grateful that you have been able to receive the services there at Big Spring State Hospital, and that they're doing well, and that you're in a much better position today than we've seen you in the past. How much that your physical health has improved also with
yes, sir.
diabetes. So hopefully we'll continue to track along and get to the point where maybe the next time we're having a hearing could be possibly an in-person hearing where you're back to Van Zandt or your home or wherever it is that you may go. So
yes, sir.
I'm thankful to see the progress. I appreciate the work that you put in to get to this point and to do what you're supposed to do there. So you're to be commended for that.
Yes, sir. Thank you.
All right, Mr. Lowe, anything further on behalf of your client?
No, I rest, Your Honor.
All right, anything on behalf of the state? Sorry.
No, Your Honor.
All right, then court, after having heard the evidence, Dr. Alpac makes the following findings. The court finds that there is a clear and convincing evidence that Robert Gerard was previously found not guilty by reason of insanity, that he was committed for inpatient mental health services pursuant to Chapter 46C of the Texas Code of Criminal Procedure. Court finds that Mr. Gerard continues to meet the criteria for extended court-ordered inpatient mental health services, specifically finding that he is suffering severe and abnormal mental, emotional, physical distress, is experiencing substantial mental and physical deterioration of his ability to function without that treatment. And the court further finds that Mr. Gerard has received court-ordered inpatient mental health services for at least 60 consecutive days during the preceding 12 months, and that based on the testimony, his condition is expected to continue for more than 90 days. Therefore, the court finds that there is clear and convincing evidence that Mr. Gerard's continued inpatient supervision and treatment is necessary. Therefore, it's mandatory. The court finds it is appropriate. So the court will find that Mr. Gerard be committed as a patient to Big Spring State Hospital or any other inpatient facility designated by the Department of State Health Services for a period not to exceed 12 months. And so I'm hopeful that, as Dr. Alpac said, that we can work on a step-down program and plan. And I'm glad to hear his testimony that they've actually already begun that process. So, so this order, Robert, will be for a period not more than 12 months. So that means if we get up to 12 months and we've not activated that plan and have in some kind of structured environment, as he said, we'll come back and we'll have another hearing and find out why things haven't gone the way that they're anticipated and expected. But I remain hopeful. I believe so does Mr. Lowe and Ms. Curry and Dr. Alpac that, as he said, he doesn't expect anything to pop up to derail us, but he wants to make sure that we are being diligent in what we're doing and we're taking the time. And you said that you wanted all of the decisions for you to be fruitful for you. I believe that's what Dr. Alpac is doing here today, so that's what the court's finding, okay? So Robert, keep up the good work, and hopefully we'll get some great information from the state hospital soon, and hopefully we'll see you soon, okay?
Yes, sir. Thank you. Y'all have a good day. Have a good rest of y'all's week, good rest of y'all's year, and hopefully get good news next time.
Yes, thank you, Mr. Gerard. And to the staff at Big Spring, thank y'all so much for making this happen for Mr. Gerard and being here for the board. All right, if there's nothing further, then we are adjourned at this. Thank you, Mr.
Thank
Lowe.
you. Yes, sir.
Hey, how we doing? Good, how are you? Doing good? I'm good.
Mr. Schmidt, are you and Mr. Mansanis ready? Come on up. All right, Ms. Fajardo, if you want to go ahead and turn your camera back on. Ms. Fajardo was here at 10 a.m. I went ahead, Mr. Schmidt, and I swore her in as a licensed interpreter for Mr. Mansanis. Give me just a moment, and I'm going to pull up my the plea agreement in this case, and then I'll call the record and we'll get started.
We have the electronic paperwork. We haven't agreed to the conditions of probation. And send that.
Just a moment, I'm going to pull up the plea agreement here. And Ms. Fajardo, Ms. Tabraham is working on setting up interpretation.
Yes, sir.
I'm going to do that as well. And we'll get him some headphones, and then I'll give you time to establish contact with him, okay?
And Judge, it's
Yes,
my
Your Honor.
understanding that the Tagalog dialect that she's speaking is a little bit different than my clients, and I would ask that she speak slowly so that there's no confusion. I think the translation is not perfect, but it'll suffice, but I'd ask you to speak slower.
Did you hear that?
Yes, Your Honor, but can I also ask for you, because when I do the simultaneous, I just try to match your speed. So if you may.
Yeah, so what I'm hearing you say is, Judge, you need to go slow, Mr. Schmidt, you need to go slow, and State, you need to go slow. Is that correct?
Yes, sir.
Okay, yes, we can definitely do that. Okay, and so I'm going to the function that I'm going to pick. That's some feedback. Say, make sure that. Yes, please. Yeah, I'm not going to start till you tell me you're ready. Okay, but I don't think he said anything, so you'll just tell him to make sure that he speaks up loudly into that microphone that's on his podium.
Up.
All right, court is now on record in cause number CR 25-133 and CR 25-134. This is the state of Texas versus Mark Joseph Mansanis. Mr. Mansanis is before the court on two felony charges, one being invasive visual recording, and the other being tampering, fabricating physical evidence. Mr. Mansanis is not an English speaking individual, and his interpretation is being provided today by Ms. Fajardo, who has already been sworn in by the court, and she is conducting the translation simultaneously with the court via Zoom. Mr. Mansanis, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Apo.
All right, thank you, sir. You can lower your. All right, Mr. Mansanis, are you a United States citizen?
No. Tipo. Permanent resident.
So you are a permanent resident, is that correct? And do you understand, Mr. Mansanis, that if you plead guilty to any crime in this court today, that it could have adverse effects on your legal status within the country?
Yes, sir. Apo.
Mr. Mansanis, you are charged by indictment with a third-degree felony offense of tampering evidence. That carries a range of punishment of not less than 2 years or more than 10 years in prison if you were to be convicted and sentenced. And additionally, you are charged with a state jail felony offense of invasive visual reporting, which carries a range of punishment of not less than 6 months in prison or more than 2 years in prison if you were to be convicted and sentenced. Mr. Mansanis, in this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney, work that he's done for you?
Yes, sir. Apo.
Do you have any questions about your plea agreement or anything else that you have read, signed, or reviewed in this case?
Wala na po, natanong ko na lahat kanina.
All right, Mr. Schmidt, as the attorney for Mr. Mansanis, do you believe that he is competent to enter into the plea agreement today. And if he is confident that he is doing it intentionally, knowingly, and voluntarily after having been informed of his legal rights.
Yes, sir.
You also explained to him the advantages and disadvantages of a deferred adjudication plea, which appears to be the plea recommendation today.
Yes, sir.
Mr. Mansanis, I see that the plea agreement today that's being recommended is upon your plea of guilty to invasive visual recording, a state jail felony, that the court, upon reviewing the evidence, if the court finds that there's enough evidence to convict you, the recommendation is for the court not to convict you, for the court to defer a finding of guilt on the allegation, for you to be placed on 3 years of community supervision. You'd also be required to pay a fine of $1,500, court costs of $290, reimbursement fees of $535. And as part of your community supervision, you would be required to comply with the sex offender conditions. And the state would be dismissing your tampering charge, cause number CR 25-134, upon you admitting guilt to that as well. Mr. Mansanis, is that your understanding of the plea agreement?
Okay.
Do you have any questions about anything before we proceed further? All right, Mr. Mansanis, the court having explained to you the range of punishment in the plea agreement, at this time I ask you, how do you plead to invasive visual recording? Yes, sir. How do you plead to the crime of invasive visual recording? Do you plead guilty, not guilty, or something else?
Guilty. Guilty.
Mr. Mansanis, are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty to this crime?
Wala po.
Court accepts the defendant's plea of guilty. Mr. Schmidt, is there any objection to the court admitting the evidence?
Okay.
Court hereby admits the evidence and takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, only that there is a victim impact statement on file. If the court doesn't have it, I can print it out.
Don't believe I have.
I just hit print, so we can get that to the court shortly here. Additionally, Your Honor, we did have a meeting with the victim in this case to go over all the options and the ins and outs, and she was supportive of the plea agreement.
Thank you, Mr. Harwell. Is there anything further from the defense, Mr. Schmidt?
No, sir.
All right, court is going to consider the evidence, review that at this time. Court has reviewed the evidence in the case. Court finds that there is enough evidence to convict the defendant of the offense. Court will follow the plea agreement recommendation of the state. The court hereby confers a finding of guilt. Mark Joseph Santos Mansanis, offense of invasive visual recording. Court places the defendant on 3 years community supervision. Confers a finding of guilt. Orders the defendant to pay $1,500 in bond, $290 in court costs, $535 in reimbursement fees. Court orders the defendant to have sex offender conditions of community supervision. Court dismisses cause number CR 25-134, tampering with physical evidence. Court hereby remands Mr. Mansanis to the probation department so they can carry out the terms and conditions of the sentence. Mr. Mansanis, in just a moment, you will report with Sergeant Martinez. He's going to take your fingerprint. After that, you will go with the probation officer. And if you need assistance in translating, then if you have a family member here with you, you can bring your family member back and they can help translate for you any further information from the probation department. You understand those instructions? Do you have any questions about anything before we conclude your? All right, thank you. Come forward to be fingerprint. All right, Mr. Hardo, thank you so much for being here. We certainly appreciate your assistance and look forward to it. Thank you for your patience.
And Your Honor, may we approach?
All right, this is cause number CR 25-199, State of Texas versus Jalen Jamal Fairley. Mr. Fairley set for docket call today. It's my understanding that the state has extended an offer. There's a request for more time to review that. The court grants the request. That's Mr. Fairley for docket call March 31st. That'll be a final docket call at 9 a.m. Once he signs his appearance, he's free to go.
All right, Judge, thank you for your time this morning.
Fairly make sure you're here at 9 o'clock, so when I call names, I don't inadvertently issue a warrant for you while you're sitting out there, okay? All right. Mr. Smith, who are you ready on?
Nathaniel Brooks.
All right, bring Mr. Brooks in here, see if he's. All right, good morning, Mr. Brooks. Can you see and hear me okay?
Yes, sir. I can hear you and see you just fine.
All right. Also, can you see Mr. Schmidt? If you're on your phone, you may have to swipe left or right to see.
Okay, yeah, I'm able to see him now.
All right, we are on record in your case, cause number CR 25-165, State versus Nathaniel Jr. Brooks. We're set for final docket call today. Mr. Schmidt.
That's correct, Judge. We were announcing ready for trial on Mr. Brooks.
All right, and what is the offer, if any, that was made by the state that's rejected by
The offer that was made and rejected is 8 years TDC, probated 5 years, $2,000 fine.
And your client understands that the court may not allow Mr. Brooks to engage in plea negotiations after today, even if the agreement gets better.
Yes, sir.
All right, court will set Mr. Brooks for jury selection. Begin that, Mr. Brooks, on March 16th. So on March 16th, you have to appear here at the courthouse. My staff will meet with you downstairs in the courthouse, and you'll check in with the pretrial release officer. You'll sign your notice of appearance, and you'll continue to do that. File. Once your case is likely to go to trial, we'll notify Mr. Schmidt. Otherwise, he will not be at the courthouse to meet unless he just wants to. You understand?
So, I want to be able to change counsel. You know, I'd rather hire me a lawyer at this point. Me and Smith have had communication difficulties at the moment, referring to my case. So I would like to change counsel at this time and ask the court for additional time to retain new counsel, if possible. If not so, then I'll do agree to your terms, and we'll try to have available counsel at your desired time, Your Honor.
Well, Mr. Brooks, the way it is right now is you asked for a court-appointed attorney. The court found you indigent, said you couldn't hire one. Court's appointed Mr. Schmidt. He is your attorney, and you're set for jury selection on March 16th. You do have the right to hire your own attorney. If you want to hire your own attorney, then you do so, and you file a motion to have your attorney will notify a motion to substitute counsel, and then you can hire your own attorney. But you are going to be required to reimburse the Mansanis County taxpayers for the money that they've expended on your behalf to Mr. Schmidt. So you're aware of that. So if you want to hire an attorney, you're welcome to do so, and we'll be set for trial, and they'll go to trial on the case.
So, in other words, I still have to pay him another $100 for his counsel or whatever, and then I'm done with Mr. Smith. That's what you're saying. That's fine.
You're not done with Mr. Schmidt until the court relieves Mr. Schmidt as your attorney. The only way that happens is you hire another attorney. They file a motion to substitute counsel, means to replace the counsel. Once the court grants that, then Mr. Schmidt will be discharged as your attorney. Your new attorney will be your attorney of the case. Your new attorney will be responsible for going to trial with you. And then
No problem.
you will be ordered by me to reimburse the county for the money that the taxpayers have spent to pay for Mr. Schmidt. So I don't know how much money that's going to be, but
Well,
yes, you
I'm not understanding. There's already an attorney fee admitted into the charges that I'm already paying, which was the amount. So I'm not understanding what additional payments I will owe Mr. Schmitz at this moment.
I understand. I don't know how much you've paid in, but whatever you have paid in is on record and you will get credit towards that. So if I order $500 and you've only paid 200, then you're going to be ordered to pay 3. If you've already paid,
Okay, I understand what you're saying, Your
if you
Honor.
paid 500, then and if that's what the court's order is, then you won't have to pay any. So he
Okay,
will not be billing you. He's
I understand the court is
contract.
billing me. The court is billing me. I do understand, Your Honor.
That's
But
right.
yes, sir, I understand what you're saying. I understand and I'm sorry, what date is that you say is required for a jury selection?
March 16th.
March 16th. Okay.
Okay. So you'll be
Okay.
we'll report here in the courthouse on March 16th.
No problem.
At 8:30. At 8:30. Okay.
Thank you.
All right, you're free to go. Mr. Schmidt, be you right now.
Deanna Dial.
Ms. Dial. File number CR 25-129. State versus Deanna Joyce Dial for final docket call. Mr. Schmidt.
Judge, we'd ask to set Ms. Dial for a plea on March 31st.
Right. That'd be an AM plea.
Yes.
All right, court sets Ms. Dial for plea on March 31st at 9 a.m. Like
Wyatt Berkman.
Wyatt Berkman. All right, this is cause number CR 24-128, State versus Wyatt Lane Berkman for docket call, final docket call.
Same announcement as separate plea on March 31st.
All right, court sets Mr. Berkman March 31st. Is that a morning plea?
Yes, sir.
At 9 a.m. That's that.
Cooksey.
Manna May Cooksey, CR 22-93. Cooksey also set the final docket call.
Same announcement as for plea date on 31st of March.
9 a.m. Yes, sir. Court sets Ms. Cooksey for plea 9 a.m. March 31st.
Susanna Frisbee.
Ms. Frisbee, it's called for CR 25-230. Ms. Frisbee set for docket call.
Judge, we're gonna ask for an additional docket call on the March 31st day.
The objection.
No objection, Your Honor.
All right, court will set Ms. Frisbee for final docket call March 31st at 9 a.m.
Joshua Chameleon.
Chameleon, CR 25-249. Chameleon is set for pretrial.
That's correct, Judge. No contested pretrial motions at this time. Ask for that docket call setting on March 31st.
Court finding there are no contested pretrial motions, assess the defendant for pretrial, pretrial, I'm sorry. Docket call, March 31st.
James Goodson.
James Robert Goodson, CR 25-250. Goodson, that for pretrial update.
That's correct, Judge. We have no contested pretrial asked for docket call setting.
Like court says, Mr. Goodson, Dr. Paul, March 31st at 9 AM. On notice, committee.
Joseph Tudor.
Joseph Scott Tudor, CR 25-28. Pretrial.
That's correct, Judge. No contested pretrial at this point. Ask for a docket call setting March 31st.
Court says Mr. Tudor then, March 31st at 9 AM. It's Sanctions. I've seen the hallway, but you West will be up.
Think Judge Michael Weaver.
Wayne Weaver, CR 5-260 and 261. Weaver is set for pretrial in the case.
That's correct, Judge. At this time, we have no contested pretrial. We'll ask for a docket call setting.
Correct court finding there are no pretrial issues at Docket call March 31st at 9 AM. Each case.
You need his email? Send it. You have my email? Well, yeah.
All right, let's go back on record. CR 25-154 State versus Christopher Wayne Blevins. Made an announcement earlier, Mr. Schmidt, that Mr. Blevins had a family emergency. And we're setting for plea on 3/31. That's correct. Is that a morning or afternoon plea or morning plea? And the family emergency, is that something that was medical related?
Yes, sir. Apparently, according to him, his mother is actively dying as we speak. I think they expect her to pass this morning.
We'll set him 3/31. Couple people that we have in custody, cause number CR 25-135 State versus Ronnie Earl. That Mr. McGee is in custody. Looks like he is in custody on decency with child exposure. Well, actually, that says to be a Van Zandt charge.
Your Honor, my understanding is that he is in custody in Smith County for the same charge, the indecency with the child by exposure.
Okay. We know that Smith County looks like the offense was December of 25. What's the state's plan for Mr. McGee?
Your Honor, we do intend to continue our prosecution. We haven't gotten an update from Smith County. Of course, that could end up being a global resolution, taking care of both cases at some point. But for now, we do intend to continue prosecution.
Do you know if he has an attorney in Smith County?
I don't, Your Honor. I imagine by now he would, given that it's been about 90 days and he's been in custody. I expect he has one, but I don't know who.
All right, court will set Mr. McGee then for status. March 31st.
And Your Honor, since he is in custody, state would ask that his bond be held insufficient. For one, make sure he gets credit time, and two, because obviously being out on bond and having the same accusation.
Any objections from the defense? All right, court hereby finds the bail to be insufficient for Mr. McGee. Court will revoke bail and sets new bail at $250,000. Court will sign an order reflecting that. And it appears that Mr. Julian Romero, cause number CR 26-5 with Zephyr Raymond, is not present today. Court will have his name called loudly, distinctly 3 times at the courthouse, will issue a judgment not signed, no response. I believe there's also concerns from the pretrial release department that Mr. Romero has not been reporting for November, December, January, or this. So. Cause number CR 25-224, State versus Jalen D. Young. Mr. Young, that's Caddo Parish, Louisiana. Any updates from the state?
Your Honor, I'm afraid I don't have an update to give the court. If we can set him for a status on 331, I can get try and get some information, see if it's give the court a plan of action at that point.
All right, court sets Mr. Young for custody and prosecution status on 331. Oh, hang on, what about Mr. Camp? Cause number CR 25-32, State versus Zachary Dale Campbell. Show Mr. Campbell. TDC. Kaufman on a 3-year sentence for possession of controlled substance. It looks like he was sentenced early December of 25. So we'll reset Mr. Campbell for prosecution status 331. We'll move that to the 130 docket because we know he's in custody.
Yes, sir.
If you know that you want him by that date, you could go ahead and request a bench warrant through Ms. Abraham. We'll get that issued.
Yes, sir.
All right, the court has had the name Julian Romero called loudly, distinctly 3 times. Courthouse with no response. The court hereby issues a judgment on I side, or if it's a personal bond, finds that bond is insufficient. Court will set new bail in the amount of $200,000. That does conclude the court's morning criminal docket. Court will stand in recess until 1:30.